What is nullification? Well, simply put, it is the idea that states can and must refuse to enforce unconstitutional federal laws. The idea of nullification is taken from the 10th Amendment to the U.S. Constitution, which states, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people." That wording, "to the people," is very important. Even though we often hear the 10th Amendment used along with the term state sovereignty, our American system of government was founded with the understanding that no government is truly being sovereign. Rather, it is the people themselves within the states that our founders considered sovereign. It is us who apportion powers between ourselves, our state governments, and the federal government. In doing so, we are not impairing our sovereignty in any way. To the contrary, we are exercising it.
We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, and among these are life, liberty, and the pursuit of happiness. He said, among these rights are life, liberty, and the pursuit of happiness. He did not list all of our rights. He just said among them are life, liberty, and the pursuit of happiness. And that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, and whenever any form of government becomes destructive to these ends, it is the right of the people to alter or to abolish it.
Because that's the two principles that we need to make the Constitution make sense. Governments are only instituted to protect our rights, and they can only operate to protect our rights if and only if they have the consent of the people to do it.
Government doesn't give us our rights, it's there to protect it. And we, the people, delegate to government at all levels, whether it be local government or state government or the federal government, those powers that we deem necessary.
Federalism is the idea that power is dispersed among various bodies in society, and in the case of the U.S. it means that you have a central government that acts as, supposed to act anyway, as the agent of the states, so it's granted a few enumerated powers, and the remainder of the powers are exercised by the states or the people.
In the American system, no government is conceived of as being sovereign. And by sovereign, I mean having ultimate decision-making power. We sometimes talk about state sovereignty, but that's just shorthand for the sovereignty of the peoples of the states. No government is sovereign. That's the old world European model that Americans fled from. It's the peoples of the states who are sovereign, and in their sovereign capacity, they apportion powers between the state governments and the federal government. And in so doing, they don't give up their sovereignty. They are merely exercising their sovereignty. They retain ultimate decision-making power.
The amazing thing is that I think people forget that that puts the federal government at the bottom of the ladder. I mean, the individual gave authority and responsibility to the state government, which then gave responsibility to the federal government. So it's been flipped. So these elected employees have been charged with certain enumerated chores, responsibilities, and you see people kicking back now because they've neglected to carry out that work. They haven't done the job that they've been hired to do.
So if the agent that they themselves created, namely the federal government, should go beyond the powers granted to it by the sovereign peoples of the states, then the very logic of the system demands that the sovereign peoples of the states, by virtue of being sovereign, have to have a last resort mechanism for intervening when their own system perverts its instrument, namely the Constitution.
The 10th Amendment defines the entire scope of federal power as that which we, the people of the several states, gave to it in the Constitution, and nothing more.
The 10th Amendment was sort of taken to be implicit in the Constitution even before it was included with the Bill of Rights, and it simply means that the federal government has only the powers that are delegated to it, and the states and the people retain the remainder. And if you look at the state ratifying conventions where the states decided whether or not to ratify the Constitution, there you see that one after the other, they were being assured that even without the 10th Amendment, the Constitution as drafted already implicitly contained this idea.
I sued the federal government based on the 10th Amendment, and probably the only sheriff in history to ever sue the federal government as a standing sheriff and win a case at the U.S. Supreme Court. And it was all based on the 10th Amendment, state sovereignty. And basically what our case proved is that the federal government is not our boss.
The 9th and 10th Amendment together give us a good guide to constitutional interpretation. The 9th Amendment says that, just because a right is listed in the Bill of Rights does not mean we don't also have other rights. I want to make clear that this is not some kind of a grant of rights. And the Bill of Rights just protects rights that already existed. But they thought that was the most important, because in their recent experience under the abuse of King and Parliament, they had denial of jury trial, violation of property rights, warrantless searches, the writs of assistance, without probable cause being given to a judge. So they had experienced gun confiscation. All those things they experienced, the whole point of the Bill of Rights was to prevent that from happening again. And they didn't trust the arguments of the Federalists were that no Bill of Rights was necessary because the new Constitution, the new government created by the Constitution, was so weak that it couldn't possibly trample on the rights of the people. That was Hamilton's argument. And the response to that was, we're not going to trust that limited, enumerated, granted power to be enough. We want to have extra guarantees. That's the point of the Bill of Rights. And Hamilton also argued that, well, if you enumerate certain rights, that will make it seem as though other rights are not retained. Another argument they gave against the Bill of Rights. That's why the 9th Amendment is there. Say, just because we list these things we think are really important doesn't mean that other things don't exist, other rights. Our rights are as innumerable as the stars, or as grains of sand on the beach.
In America, we've got a constitution, and the entire constitution is just completely saturated with these principles of state sovereignty. Article 1, Section 3, Article 1, Section 8, Article 2, Section 2, Article 4, Article 5, the 9th Amendment, the 10th Amendment, all this has to deal with state sovereignty, making sure that the federal government stays extremely limited so that way we, as individual citizens, can have the most influence over local government so that way we can protect our rights. We don't have to rely on Washington, D.C. to protect our rights if they would just follow the Constitution.
I think of the 10th Amendment now, it's a relic of our failure. And future historians will look back and they'll see all the things that contributed to the demise of American prosperity, and they will say, but all they had to do was follow the 10th Amendment.
A government without limits is the definition of a tyranny. When it enacts laws or regulations or rules or mandates that are outside the scope of its constitutionally delegated powers, you are not bound to obey them.
Jefferson said, an act of Congress which assumes power not delegated by the Constitution is not law, but it is altogether void and of no force.
Even Alexander Hamilton, who never saw a big government program he didn't like, said in Federalist 78 that there is no position which depends on clearer principles than that every act of a delegated authority contrary to the tenor of the commission under which it is exercised is void. No legislative act, therefore, contrary to the Constitution, can be valid. To deny this would be to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves, that men, acting by virtue of powers, may not only do what their powers do not authorize, but what they forbid. He said, look, if they're not null and void, that means they can do whatever they want, even what they're forbidden to do.
Thomas Jefferson once said, whenever government is drawn to Washington, D.C. as the source of all power, it'll completely defeat the purposes for which we separated in the first place. Guess what? We're there.
Madison said the power of the federal government is enumerated. It can only operate in certain cases. It has legislative powers on defined and limited objects beyond which it cannot extend its jurisdiction.
The federal government, said Jefferson, cannot have a monopoly on determining what its own powers are, because we all know what it's going to do. It's going to suddenly determine that it has more and more and more and more and more powers. It's going to keep on discovering these vast, untapped reservoirs of power. We all know this. I mean, this has happened. It's not like I'm talking theory up here. Just look around, look at the Constitution, then look at what we live under. This is what has happened.
Thomas Jefferson, among other distinguished Americans, believed in the sovereignty of the people within the states. In his draft of the Kentucky Resolution of 1798, he first introduced the word nullification into American political life, and follow-up resolutions in 1799 employed Jefferson's formulation that, quote, nullification is the rightful remedy, end quote, when the federal government reaches beyond its constitutional powers. In the Virginia resolutions of 1798, James Madison said, the states were duty-bound to resist when the federal government violated the Constitution. Jefferson warned, if the federal government is allowed to hold a monopoly on determining the extent of its own powers, we have no right to be surprised when it keeps discovering new ones. If the federal government has the exclusive right to judge the extent of its own powers, it will continue to grow, regardless of elections, the separation of powers, and other much touted limits on government power. In his report of 1800, Madison reminded Virginians and Americans at large that the judicial branch is not infallible, and that some remedy must be found for those cases in which all three branches of the federal government exceed their constitutional limits. There are several examples in American history of states nullifying federal laws believed to be unconstitutional. One of the more well-known was the Fugitive Slave Act, when northern states refused to comply with the law that stated that they must return runaway slaves to their masters in the southern states. Believing the law to be a violation of Black Americans' constitutional rights, northern states nullified the Fugitive Slave Act. Another more recent example was the 2005 Real ID Act. Due to non-compliance by the states, the federal government backed off the Real ID 4 separate times.
The nullification discussion you've got to keep in mind when you refer to the founders. The founders were discussing a very narrow range of federal options. They never envisioned a notion of where the federal government would impose uniformity on the states in a host of ways. They embraced state differences, huge state differences. As a matter of fact, when our Constitution was established, many people don't know this, several states had established churches. And they did for a long time. The federal government didn't try to stamp that out. Now, I'm not saying it's a good idea, but I'm just using it as an illustration of examples of differences. The states were the laboratory of democracy, and they were free to function very differently. What has happened recently is the federal government has pressed the states into the same mold, so they become not much more than poorly paid provinces of the federal government. That's why you're seeing the resurgence in the idea of nullification. And I don't think we should get hung up on terms. We can call it nullification from the negative, or from the positive. We can say limited government. We can talk about state sovereignty. It's all the same notion. The federal government has a lane it's supposed to be in, and the states have their own lane, and then the people have the biggest lane. We flipped that around. And so that's why what the founders were saying about it is instructive, but in a sense not determinative, because they never envisioned a world where the federal government would occupy so much of our activities.
Many would agree that the founders never envisioned the gross overreach of the federal government and the numerous ways in which many Americans feel their constitutional rights are being violated today. Obamacare, federal gun regulations, NDAA, NSA spying has put the concept of nullification back in the news. However, nullification certainly does have its detractors.
The concept is called nullification, or state sovereignty, the notion that states can opt out whenever the federal government tries to exert a power not enumerated in the Constitution.
And as well as being a rabid proponent of slavery, John Calhoun, to that end, championed the cause of nullification. Nullification, the idea that states could and should refuse to follow federal laws they didn't like, that they thought went beyond the powers of the federal government.
If you're a little rusty on the Constitution, here is what the 10th Amendment says. Quote, the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. The one little problem with the argument from the Tenthers, as they like to call it, is this other part of the Constitution that's called Article 1, Article 1, quote, the Congress shall have power to lay and collect taxes, to pay the debts, and provide for the common defense and general welfare of the United States. That means it unambiguously authorizes Congress to spend money in ways that benefit the nation. Social Security, Medicare, Veterans Care, et cetera, et cetera. So what are the Tenthers really up to?
The problem with those that are looking to the 10th Amendment for support is that the Supreme Court really offers very little encouragement for these types of claims.
A conservative group called the 10th Amendment Center has been pushing a lot of the anti-health reform stuff, but they put that in the context of nullification, and they're pushing for other kinds of nullification, too.
Ron, most people in their right-thinking mind know that the 10th Amendment is a bunch of baloney.
Since the election of a black president, dozens of states, primarily red states, have flirted with sovereignty, some actually passing legislation declaring sovereignty on what they consider state issues.
Your federal laws don't apply here, Yankees. United States, schmoonited States.
The misinformed media typically refer to nullification as a controversial century-old maneuver. They may even cite the Attorney General of Idaho, his legal opinion discounting nullification, saying there is no right to pick and choose which federal laws a state will follow. But it isn't about picking and choosing or what anyone likes. The founders intended nullification to be very specifically about the Constitution. Modern-day attorneys are taught that state laws nullifying federal law would eviscerate the Supremacy Clause. It would flip the Constitution on its head and return us to the days of the Articles of Confederation, which the framers rejected. That analysis may have the virtue of some contemporary consensus among law academics, but it does not have the virtue of being the truth. In law school, aspiring attorneys are taught the Supremacy Clause of the Constitution, which states, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding." The assertion of nullification, which Thomas Jefferson commended, is that unconstitutional laws are not pursuant to the principles stated in the Constitution. That is why all officials at every level in the United States must swear an oath to the Constitution and hold all others accountable to it. Like all other officials, the judiciary are not independent of constitutional accountability. In the United States, there is no entity vested with absolute power. The Supremacy Clause does not mean that states are bound by any law that Congress wants to pass. As pop culture voices might imply, it means that states are bound to the principles of the Constitution and the enumerated powers of the federal government. Some would argue that the Supreme Court had frowned upon the idea of state nullification and misguidedly cite the 1958 state laws banning compliance with the desegregation ordered in Brown versus the Board of Education. However, being a Supreme Court decision and not legislation passed by Congress, some southern states continued to refuse compliance. As we know, those states under the Kennedy administration were forced to desegregate in 1962 and 1963.
The next day, Sunday, September 30th. Finally, President Kennedy decided the time had come to enroll James Meredith at Ole Miss. He sent several hundred U.S. Marshals to the campus to prepare, and he announced he'd make a special speech to the state that night. And during the night, 35 Marshals were shot, and 2 people, a French journalist and an Oxford worker, were killed. But by dawn, the Army had restored order.
And refuse to wittingly submit to illegal usurpation of power by the central government.
After the federal officers leave, there's a lull of several hours while President Kennedy federalizes the Alabama National Guard and they move to the campus. Brigadier General Henry Graham arrives to tell the governor, "It's my sad duty to ask you to step aside on orders of the President of the United States." The governor yields to federal authority.
It is worthy to note, however, that using the desegregation nullifications of the early 1960s as proof that nullification cannot work in today's constitutional crisis is an error. The point of these civil rights events was that equal protection under the law was precisely pursuant to the constitutional principle of equality under the law. The 14th Amendment had corrected the flaw in American practice, which had not recognized an entire class of human beings, Black Americans, as equal under the law. And the 1964 Civil Rights Act identified and addressed specific laws that continued to do so, bringing further correction to the unconstitutional practices. The Southern states were not nullifying the federal requirements because they were unconstitutional, but simply because they did not like the law. That is a misuse of the 10th Amendment and the concept of nullification. Another example, both conservatives and liberals who are concerned about using the concept of nullification cite is what is commonly referred to as the nullification crisis of 1832. However, is it possible the idea of nullification reining in an overreaching federal government actually worked in this case as well? Let's listen to some commentary from the 10th Amendment Center on the nullification crisis of 1832.
Resistance is not futile. Forgotten lessons from the nullification crisis. A 10th Amendment Center featured article by Josh Ebach. Even as calls for nullification of federal health care mandates have intensified on the state level, an almost hysterical effort has arisen to discredit such measures and paint them as part of an obsolete theory, with no bearing on modern politics. Regardless of its logical descent from our most basic founding principle, that governments derive their just powers from the consent of the governed, nullification simply doesn't work, critics say. Or does it? While it's true that our system of checks and balances has been weakened substantially over the years, federalism itself has not. Divided power remains as viable a structure of government today as it was the day our Constitution was ratified. Perhaps a better question is this: can nullification succeed peacefully? Of course, it already has. For proof, one need look no further than the truth behind a favorite parable of establishment statists, the nullification crisis of 1832-33. Over the years, that crucial victory for the sovereign states has been converted into a cautionary tale by those who wish to discourage taxpayers from ever questioning their federal masters. So distorted is the history that a recent article on modern nullification efforts in the Nashville City paper declared, quote, "In the nullification crisis of the 1830s, South Carolina passed a law nullifying federal tariffs, but the state backed down after President Andrew Jackson sent Navy warships to the Charleston harbor." End quote. The only problem with that story is this: it never happened. After nullifying the so-called Tariff of Abominations in late 1832, the citizens of South Carolina began making serious preparations to defend themselves with deadly force against any attempt by federal agents to collect the hated tax. What followed was a tense standoff between President Jackson and a relatively small group of determined citizens that could easily have resulted in secession or war. But those citizens refused to be intimidated by Jackson's repeated threats of violence, and they certainly didn't surrender to warships in Charleston Harbor. As Wikipedia admits, it was not until the end of February 1833 when, quote, both a force bill authorizing the president to use military force against South Carolina and a new negotiated tariff satisfactory to South Carolina were passed by Congress, and that the South Carolina Convention then reconvened and repealed its nullification ordinance. End quote. From that point on, right on up until the war between the states, the tariff rate declined steadily. In other words, after putting the federal government on notice that they were prepared to defend their sovereignty with force if necessary, the people of South Carolina agreed to abide by a new negotiated tariff that they felt was fair, rather than fight a war or leave the Union, neither of which they wanted to do in the first place. A clear victory for nullification and for peace. In fact, the entire episode is more or less a perfect demonstration of how robust federalism and divided power once protected liberty within our voluntary union, by keeping the ambitions of the central government in check. So why the modern spin on this event as some kind of heroic unilateral militarism by President Jackson and a watershed moment for centralization? Well, for one, that interpretation fits with what statists would have us all believe anyway, that there is no force on earth, including public opinion, capable of resisting orders from the national government. It also makes for a neat segue into the conflict that erupted 30 years later along the same fault lines of federal versus state authority, providing a convenient way to dismiss, without debate, those who call for nullification today, by linking them with slavery and the antebellum South, at least in the eyes of a historically ignorant public. Yet, from the Fugitive Slave Act to Real ID, American history is replete with examples of states successfully asserting their sovereignty in constitutional disputes with the federal government, and there is every reason to believe that they could do so again with regard to health care, should it prove necessary. If the federal mandates are so unpopular in any given state that a majority of its people support legislation or a state constitutional amendment to nullify them, that should be a clear indicator to President Obama and Congress that the governed have withdrawn their consent. Any attempt to assert federal power in the face of such popular opposition will inevitably be seen by the citizens of those states as illegitimate and unjust. At that point, it will be up to those in Washington to decide whether they want to respect the natural laws on which our nation was founded, or whether they would prefer to wager their lust for power against the full electoral fury of the sovereign people's wrath.
In spite of the robust debate that the topic of nullification brings, many Americans are realizing that we must look at all of our lawful and peaceful options to constrain a clearly out-of-control central government. Intrusion into our private lives, our medical decisions, NSA spying on Americans, indefinite detention of American citizens in the NDAA. Obviously, focusing on local and state approaches to these problems may provide an answer.
You've got to shore up your state and your town. There's something else that Texas did, and I think 22 other states are starting to do, but Texas has done the best, and that is the nullification of the NDAA. But what they've done is they've not only nullified the law, which 10 of these other states have also done, They have bills now ready to be passed in 10 other states that say, no, I'm sorry, the president cannot do that. Not in this state. We don't play ball that way. You cannot do that to our citizens. Texas has taken it the step further. If you comply with this executive order in any way, if you aid the federal government in any way to help scoop a Texas citizen off the streets and put them into federal custody under this particular thing, you'll go to prison in Texas. And that's the way it should be. It's not just, hey, we don't do that here. It's not only do we not do that here, it's against our state law to do that here, and you will have a hefty prison sentence if you're involved at all.
Nullification is an idea whose time may have come again. One thing we do know, Americans must act, or liberty may be lost, and once lost, may be lost forever. Let us remember the encouraging words of Ronald Reagan in his inaugural speech.
So as we begin, let us take inventory. We are a nation that has a government, not the other way around. And this makes us special among the nations of the earth. Our government has no power except that granted it by the people. It is time to check and reverse the growth of government, which shows signs of having grown beyond the consent of the governed. It is my intention to curb the size and influence of the federal establishment and to demand recognition of the distinction between the powers granted to the federal government and those reserved to the states or to the people. All of us need to be reminded that the federal government did not create the states. The states created the federal government. Now, so there will be no misunderstanding, it's not my intention to do away with government. It is rather to make it work. Work with us, not over us. To stand by our side, not ride on our back. Government can and must provide opportunity, not smother it. Foster productivity, not stifle it. If we look to the answer as to why for so many years we achieved so much, prospered as no other people on earth, it was because here in this land we unleashed the energy and individual genius of man to a greater extent than has ever been done before. Freedom and the dignity of the individual have been more available and assured here than in any other place on earth. The price for this freedom at times has been high, but we have never been unwilling to pay that price. It is no coincidence that our present troubles parallel and are proportionate to the intervention and intrusion in our lives that result from unnecessary and excessive growth of government. It is time for us to realize that we're too great a nation to limit ourselves to small dreams. We're not, as some would have us believe, doomed to an inevitable decline. I do not believe in a fate that will fall on us no matter what we do. I do believe in a fate that will fall on us if we do nothing. So with all the creative energy at our command, let us begin an era of national renewal. Let us renew our determination, our courage, and our strength. And let us renew our faith and our hope. On the eve of our struggle for independence, a man who might have been one of the greatest among the founding fathers, Dr. Joseph Warren, President of the Massachusetts Congress, said to his fellow Americans, "Our country is in danger, but not to be despaired of. On you depend the fortunes of America. You are to decide the important question upon which rests the happiness and the liberty of millions yet unborn. Act worthy. of yourselves.
It is truly a time to act worthy of ourselves, worthy of the heritage that is ours. We must not allow the freedom that so many have died for to slip away.